Good morning and welcome to UPN Focus. I'm your host, Milt Thompson. Murder, drugs, intrigue, major league crime. We're going to talk about that this morning in the terms of federal court defense of major crimes. We're going to do that with our very, very special guest today, Linda Waggoner, counselor, lawyer, federal defender, and Jessie Cook, lawyer, counselor, federal defender. Ladies, good morning.
Good morning.
And welcome to our show.
Thanks.
It's nice to have you here. You know, when we're talking about the law, a lot of people in our audience here pretty much get what they see on television or read in the news journals about what really goes on in a courtroom and what goes on in criminal cases, and they're always seeing the bad guy. And the first question every one of them asks, how can a lawyer represent these bad guys when they know something's bad? Well, I want to know from each of you, why do you get yourselves into criminal defense at the federal level? Jessie?
Well, I think it's no different than being in criminal defense work on the state court level. A number of the cases in which we represent defendants are appointed cases, and for me, in private practice, some of them are clients who come into the office. The cases are the same whether there is any underlying belief that the client is guilty or not guilty. I mean, we think everybody is entitled to have good representation. And certainly there are a large number of people who are accused of crimes who are not guilty, either of any crime at all or of that specific crime that they're accused of.
But you know how it is when people are saying, you see the smoking gun and you see all the evidence around that someone really truly is a bad person, and you know the old joke that, yeah, you know, the reason why they're in prison is because they deserve to be in prison. Linda, you've chosen to do this as a profession full time. Why did you get into this kind of practice?
Into criminal defense or into federal public defending?
Federal public defending. That's a choice.
I always wanted to be a public defender full time because I didn't like some of the choices that I had to make economically in private practice in determining whether or not to take a case. And I truly enjoy the criminal arena. I think it's very important that we defend the Constitution as well as the rights of the least of us. And the federal system was the only one, frankly, that provided me with an opportunity to do that at an income level that was acceptable.
Well, you've already mentioned, Jessie, you don't believe that there's any difference in criminal defense at the state and the federal level. A lot of people really don't know the difference. Sometimes, I remember in law school I took Fed Jur, and I'm not sure I know really what the difference is all the time. What really requires one to be in a federal jurisdiction versus that of a state jurisdiction? Are there reasons that are easy for us to understand?
Well, sometimes it's interchangeable because we have clients who are charged initially in state court and then charges are refiled after a grand jury indictment in federal court. So there are a vast number of charges that can be filed either in state court or federal court, and it just depends on which forum the prosecution chooses. The crimes that are uniquely filed in federal court are those which are just violations of federal law as opposed to violations of state law.
In fact, there's a considerable concern around the country that Congress has federalized too many things, that crime and punishment and things of that nature are things that the forefathers originally left to the states, and now the federal government has kind of tried to come in and say we can regulate everything criminal, and that's so it leaves it totally, as Jessie said, up to the discretion of the prosecutor, and each prosecutor's office, I suppose, has its guidelines on when state prosecutors will look to the federal authorities, and the federal authorities, I know, have their guidelines on when they will accept a case.
Are federal penalties tougher than state penalties, or is there a reason why one would look as a forum, if you're a prosecutor, to go to the federal courts? Is there more resources devoted towards the prosecution at the federal level, or well, why would one choose to have a case prosecuted at that level versus the state level?
Well, I think clearly there are more resources available at the federal level, and there are amounts of funds that are dedicated to the prosecution of certain kinds of crimes in federal courts, such as the possession or use of firearms by felons. Those are areas in which the federal authorities have decided to really devote funds to it. And so a lot of the state court prosecutors will refer firearms cases to the federal authorities simply because they have the greater resources and the more interest to prosecute them.
Almost universally across the board with respect to drug crimes and firearm offenses, the penalties are much more severe in federal court, substantially more severe. It's not necessarily true with some economic, typical white-collar or fraud-type crimes, but certainly drugs and guns, the penalties in federal court are very severe.
Any additional training that you have to have in order to make the adjustment from federal courts to the state courts?
Just you have to know the sentencing guidelines, and you have to forget logic, because everything, for instance, you learned in law school is almost inapplicable in federal court.
You know, a lot of what we do in state court in terms of sentencing hearings is to argue to the court what mitigating factors there might be that have to do with our client's own background. And most of those kind of mitigating factors are of no effect when you're talking about sentencing in federal court, because the federal judges have so little discretion anymore in terms of the sentences that are imposed.
The two of you were involved in one of the more notorious trials in our community in a long time. I think it was entitled The Ghetto Boys, and this was a trial.
It wasn't the Ghetto Boys.
It wasn't
case.
The Ghetto Boys? What
that
case
was another. That was another case.
Right.
Do I have the wrong case?
Yes.
What case are we talking about?
The Baha Boys.
Oh, the Baha Boys. Well, the Ghetto Boys, Baha Boys are all bad guys. That's kind of what goes on. The Baha Boys was a group of drug dealers.
Actually, the Baha Boys is a misnomer. I mean, the government created the term, the Baha Boys, and they got it simply because there were a number of the defendants who were either employed by or had an ownership interest in a bar that was called the Baha Bar and Grill. And so they named the group of people who frequented the bar as the Baha Boys. It was not a gang of any kind.
For some federal prosecutions, particularly drug prosecutions, there's a special fund, as Jessie referenced earlier, and in order to qualify for those funds, there has to be a name that the government refers to the case by, and then it qualifies for payment of state officers by federal funds and some other things. But there's some stringent requirements the government has to meet, and that actually the Baha came out of that.
So they call the Baha Boys. You prefer to call it individual clients
Sure,
and trials with individual defendants,
Sure.
and had that. But the underlying case was murder and drugs and intrigue.
There was an allegation that an individual who had been an informant for the government was murdered by one of the members of a group that the government believed to have been involved in a drug conspiracy.
And this case took a long time to try, a large part of your lives, and really had some interesting outcomes that we're going to talk about in our next segment. Really appreciate you giving us some insights about the world of federal prosecution and defense. We'll come right back after this moment. And welcome back to UPN Focus. We've got a very, very interesting topic this morning. We're talking about criminal defense at the federal level. We're doing that with our very special guests, Linda Waggoner and Jessie Cook, two federal defense lawyers who participated in a huge trial that lasted a couple of months called the Baha Boys, and it was a murder and drug conspiracy case and had all of the excitement and intrigue that the media paid a lot of attention to that case. To the outside world, what they may hear and read in terms of what the evidence was or what the evidence wasn't, then an ultimate result, take everybody behind the scenes a little bit if you can. And what was there with your preparation for this case, interviews with witnesses and with the FBI and all the things that go on behind the case, and what you did to get yourself ready to prepare this case?
Well, the case was actually years in the making, and Linda was involved much longer than I was. I was appointed about 90 days before the trial actually started to represent Anthony Spradley. And so I think for the next 6 months, what I did to get ready for the case was largely going through some of the work that Linda had done beforehand. We were lucky to have access to a couple good investigators, but you know, as you can imagine, there were an awful lot of witnesses to be interviewed, and not just interviewed, but to be located. People who don't necessarily go to the same home every night, that have to be tracked down and interviewed.
How many defendants were in this case?
Well, there were at one time there were 16 that were charged, and then for reasons that are not particularly clear, the government superseded that indictment and ended up with 13. 3 of those pled before or during trial, so there were 10 of us who actually went to trial. It was, a lot of people may not know this, but in the federal system, the defense has the right to interview witnesses, but the government frequently makes it very difficult. And in this particular case, they must have had at least 10 snitches, we call them, people that they have given leniency in exchange for their testimony, and those people they're very protective of, and they keep them away from us as best they can. This case was kind of interesting because I had a client who had helped the government in a totally unrelated case, who was housed with several of the government snitches in this case, who was feeding me information, which helped us a great deal and upset the government a lot. So that was a little bit fun and a little bit of an interesting twist in the case. But there were over 10,000 documents and 500 exhibits, and I mean, it was a lot of just organizational preparation that was kind of tedious.
With that many defendants, you probably had a lot of lawyers. There were more lawyers than just the 2 of you in that courtroom, were there not?
Sure, there were 10 lawyers in the courtroom. One of the other things...
There were 13.
Well, with the government attorneys.
13 lawyers.
10 defense lawyers. One of the other things that makes a federal trial much more difficult than a state trial is that we don't have the same right to get the government's evidence well in advance, so we don't have an opportunity, an adequate opportunity to prepare for trial. And in this particular case, we were receiving massive amounts of information, including grand jury testimony of government witnesses, immediately before the trial began.
Well, Jessie came into the case 90 days prior to the actual trial. Linda, you were involved in that trial far before that.
Right.
And what was your role in trying to organize all the evidence and try to perhaps orchestrate all the lawyers and their roles and how and when they get to actually examine a witness and when they might be able to give a closing or an opening argument? What went on with all of that, and how did you orchestrate that?
Well, my client happened to be arrested fairly early on. And that was why I was in the case from almost the beginning. So I just was able to organize better, I think, as the case went along. I don't know how Jessie did that. In terms of examining witnesses, we knew that the witnesses would not all talk about all of us, and we didn't want to just go in the same order all the time. So we got the judge to agree that we would pass him the order that we wanted to use for examination, and then we would kind of brainstorm. We had a room in the courthouse that we met, and we had sufficient breaks during the trial. We go, who wants to cross-examine this witness, and what do you want to bring out? And sometimes some attorneys would want to get the witness to agree about some things, while other attorneys wanted to attack the particular witness. So we'd kind of talk about strategically, who goes first, who goes second, who covers which topics, and we tried not to bore the jury with all of us hammering on the same things. We tried to divide up the topics as best we could to keep it interesting and moving, and I think we did a fairly successful job of that, actually. But it was truly a group effort. It was interesting.
Major grave consequences in a case like this means someone's liberty is going to be restricted, perhaps even for a lifetime, when you're talking about murder and the underlying conspiracies for murder as well as the drugs. The responsibility that you have as defense lawyers, how do you cope and deal with that? That the outcome of your work may have a bearing on someone's liberty, particularly, as you suggested earlier, Jessie, if in fact someone is in that system unjustly.
Well, that's an incredibly difficult problem, and especially in federal court, where someone who is convicted of the drug offense is facing a lifetime in prison, even if they're not convicted of any of the crimes of violence which were alleged in this case, and that in fact is what happened with my client. He was found not guilty of the murder, he had not been convicted of any violent acts, and yet he ended up receiving a life sentence. I think that makes all of us feel as though we have to devote every single minute that we have to preparation and trial, and that's what happened in this case. The attorneys that ended up going to trial, I think Linda will agree, we worked together constantly. We were there in the Federal Community Defender's Office, which provided a lot of resources to us in space, and we were there over the lunch hours, we were there every evening. There isn't anything that we thought needed to be done that we didn't make an effort to do, but it's very personally taxing.
Your client goes to prison for life. Your client was exonerated.
Yes, but he spent 20 months in jail.
20 months in jail, but ultimately acquitted of all the charges.
Yes.
What was the difference?
Well, the evidence against my client was, it came in very fortuitously. We were able to develop a very positive theme for my client that held throughout the trial, that he didn't ever drive any fancy cars, he never participated in any drug transactions, he didn't have fancy clothes, he didn't do all these activities that people, that the police were trying to say that the drug people did. And it was a truthful presentation. On the other hand, Jessie's client was the lead person in the government's eyes. Literally every witness they called, they tried to focus on him. And you know, when you have that much power and resource focused on an individual, you can take the most innocent of actions and put a spin on them to make them look very, very bad. And that indeed is what the government did in this case. I mean, they had a lot of witnesses with a lot of bad things to say that were virtually unchallengeable. You know, somebody says, well, yesterday I saw such and such. No other witnesses, no cooperation, they had no drugs they introduced, you know, things like that. It was a very unusual case.
I think one of the things that you have to understand is these aren't typical witnesses. The witnesses that the government called who testified against my client were for the most part individuals who were in serious criminal trouble or in state court trouble themselves. And they had everything to gain by their testimony, and they were gaining a great deal by their testimony. For example, the government may have promised someone who was himself facing life in prison that he would get a sentence of a couple years prison time. But in exchange for that, he was expected to testify, and specifically to testify against my client. And the kind of testimony that they provided are things, like Linda said, it's very difficult to attack. If someone said 3 years ago, I met someone in the hallway of a building and there are no other witnesses, but we conducted a drug transaction.
You know, there have been so many sensationalized cases on television or otherwise, the Marsha Clarkson, the O.J. Simpson trial, and you hear things of jury nullification, throwing people all in the same bathwater and throwing them out with all of that, and working through these distinctions is really, really interesting stuff. We're going to come back and talk a little bit with Linda and Jessie about women in the practice of law and criminal defense level, and what difference does that make? We'll be right back after these short words. Welcome back to UPN Focus. We've been talking about crime, intrigue, federal defense at the major level, murder trial, drug trial. When you typically think about that, you think about men in this role of defending these alleged criminals. Obviously, you two are not men, and you are in that role. Have you had any feelings or sensations of patronage by the men or the judiciary or otherwise, or a sense of discrimination of any sort in your professional representation of these clients?
Well, I think the times have certainly changed. When I started practicing, and I'm not going to say how long ago that was.
I know how long ago that was.
But I did feel that. And I think that there were judges who thought that women, including myself, were not capable of representing men in serious criminal matters, particularly if they were sex offenses. I don't feel that anymore. And I can't say that there was any discrimination against us in this particular federal trial that we've just discussed. Among the 10 attorneys in the trial, 10 defense attorneys, 3 of us were women, and among the 3 prosecutors, 1 was female. I feel like we're treated equally in federal court, particularly these days, and there doesn't seem to be any stigma attached to assigning appointed cases to women as opposed to men, regardless of the nature of the case.
Do you feel that the same way, or do you feel there's some stigma attached?
I don't think there's any stigma attached anymore. I would agree with Jessie, but certainly when I started there was, and not only when I started practicing in Indianapolis, but after I'd practiced about 10 years, I moved to Fort Wayne, and it was like 10 years earlier because I ran into the same thing there that I had run into when I started. But now I don't think so.
Well, what about the reaction from your clients? Do you have you when you go to interview them and they discover that it's a female? Do they say I want another lawyer, or do they or is that an advantage perhaps that in some of these cases that you are a woman?
I think a lot of the clients perceive it to be an advantage, and I'm not sure why they have that perception, but I have not had the reaction from male clients that they feel uncomfortable in being represented by a woman.
Now, there still are some clients that I run into occasionally that are pretty chauvinistic and just have a hard time dealing with women generally, but I would say they're rare.
Do you ever fear for your own safety when you are in these matters? Sometimes you're around people, sometimes with alleged of very, very, very violent and or bad acts. And in many cases, when convicted and the evidence is overwhelming, perhaps you are dealing with some very, very, very bad people. Do you ever feel for your own personal safety, or do you ever have to have protection or otherwise when you are around these kind of cases?
Well, I always view it as clients who have been accused or convicted of bad acts as opposed to bad clients. And no, I never have any fear of my own personal safety, and I've been working in the jails and in the prisons for over 20 years now, and I've never had a single incident where I was either accosted in any way or really felt as though I was in any danger at all.
You same, Linda? Or you probably she said, "Well, you were lucky, Jessie, because I don't think we're going to have the same answer from Linda."
No, I had a client take a swing at me, but I wasn't fearful of that. It was an odd circumstance. And I had another person who I actually never represented who has stalked me for years, and I fear him greatly. But other than those two things, my clients, I'm on their side. You know, I'm helping them. I'm helping protect them. So no, I don't fear from them.
Well, I think one of the things that you have to be aware of is that an awful large number of criminal defendants have mental health problems. And it's not related necessarily to the nature of their charges. So we might represent someone in a very minor offense, such as a DUI or a minor theft case, who is in fact a more dangerous individual, if you want to call it that, than a person who's charged with a major crime.
Intriguing profession. Well, thank you two so very much. We're going to come back and hear a little bit more about what's going on around our town in Indy from Amber.
Thanks, Milt. Here are some events in our area for you to focus on.
Thank you, Amber, and thank you, Linda Waggoner and Jessie Cook, our very special guest here, talking about a very, very, very interesting and intriguing issue here on UPN Focus. Hey, you have a good weekend. We'll see you next week.